Right. Good morning, everyone. I'm Judge Jackie Powell. This is Magistrate Court. Today, I will let you know if I've determined probable cause, and then we will talk about release conditions. Please note that today is not your trial date, and so I encourage you not to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at a later time. If you are represented by counsel, either from the Public Defender's Office or if you have private counsel, I encourage you to speak with those attorneys before speaking on the record. If you have a private attorney, they will come to the courtroom and will be able to speak on your behalf. If you have an attorney from the Public Defender's Office, I do have Attorney Brian Reedy sitting in the courtroom with me, as well as there's an attorney with you over at the main jail. Also in the courtroom, I have the state attorney represented by Mr. Eric Linder, and then I have confinement status and pretrial supervision and the clerk of courts as well in the courtroom. I will call each person individually and we will address each person in that fashion. Is there anyone that the jail has asked to call out of turn?
Yes, there is, Your Honor. There's one gentleman on page 9, Mr. Michael Mobley.
Mr. Mobley?
Case here, President Judge Main approaching. Come on up, sir.
All right, Mr. Mobley, Mr. Mobley is before the court this morning for trespassing. And the court finds probable cause, and I'll hear from the attorneys.
Judge, and speaking of Mr. Mobley, I believe he wants his day in court relating to the trespass. My understanding is he was there seeking help. Things escalated, but in speaking to Mr. Mobley, he's asking me to request the court for a straight ROR on this trespass offense.
Your Honor, Mr. Mobley wants help, then I would suggest that this case be transferred to Judge Lerner Wren.
That's what I'll do. At this time, I'll sign an order to transfer to Judge Lerner Wren based on the allegations in this probable cause affidavit. Okay? All right, Shalimar Wright. It's a municipal ordinance matter.
She's a medical research, Your Honor.
Ms. Wright is a medical reset. Thank you.
You're welcome. Good
Esther
morning.
Edison. Good morning, Deputy. Esther Edison.
Morning. Morning, Judge.
Good morning, Mr. Plant. All right, Ms. Edison is before the court on the municipal ordinance violations for soliciting and no OSHA vest. What, Ms. Edison, can you hear me, ma'am?
Yes.
Ma'am, what do you wish to do today?
Would you like to resolve your case?
Yes.
Ma'am, do you understand where you are today?
Yes, I do.
Where are you?
At the jail.
Okay. All right,
Howard
so,
County Jail.
all right, so do you wish to resolve your case today?
No, not today.
Do you want to work out resolve the case today?
No, not today.
All right, so then I'll sign the order finding probable cause, and I'll leave her bond in place. Robin Simons,
Medical reset.
thank you. Ms. Simons is a medical reset. All right, I'm gonna be on a brief recess. Okay. Let's continue with Tia Mack.
Chair President May?
All right, Ms. Mack is before the court this morning. Charge number one, possession of drug paraphernalia, and number two is a misdemeanor capias. Also for possession of drug paraphernalia. I did not, unless I missed something, I see the capias for the possession of drug paraphernalia, but I didn't see another report for another possession of drug paraphernalia.
Yeah, that's fine, Your Honor. She can be ROR'd on count one.
All right, so no PC on one, and she'll be ROR'd on count one. And Ms. Mack does have a KPS bond of $250, and she does have court on the 13th before her division judge. What does Ms. Mack?
Judge, and speaking of Ms. Mack, she wishes to try and resolve count two, the drug paraphernalia.
Okay. Does the state have an offer?
Offers time served, Your Honor.
All right.
She wishes to accept the state's offer.
All right. Ms. Mack, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, Ms. Mack, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you need any more time to speak with your attorney?
No, ma'am.
And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that prior treatment that would affect your making a decision today?
No, ma'am.
And, ma'am, do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence on the capias is adjudication and time served. Good luck. Vicky Nugent.
Firearm facility, Your Honor.
All right, good morning, Ms. Nugent.
Good morning.
You are before the court on 3 municipal ordinance violations, and the court finds probable cause. Ms. Nugent, what do you wish to do today?
Resolve.
Okay. If you wish to resolve your case today, you'll be sentenced to adjudication and time served. Do you wish to accept that?
Yes, ma'am.
All right, Ms. Nugent, then please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Then you can put your hand down. And Ms. Nugent, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
And do you need any more time to speak with an attorney?
I don't. No.
Do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for mental or emotional illness?
No.
And ma'am, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Ms. Nugent? Guilty or no contest?
No. No contest, ma'am.
I accept your no contest plea. I find that it's freely and voluntarily given. And your sentence is on all 3 counts, adjudication and time served. Good luck.
Thank you.
You're welcome.
Go home.
All right, Lauren Anderson,
She's also in Paul Ryan, Your Honor.
okay. And Ms. Anderson is before the court on a grand theft charge,
Yes, ma'am.
and the court finds probable cause. Does the parties wish to be heard as to bonds?
Yes, Your Honor. Ms. Anderson, on count one, received a 364-day Broward County Jail sentence.
Okay,
Her release date is August 25th. I advise Ms. Anderson that she will be going back in front of her division judge. Probably both of these charges should have been run together initially, but they were not. So I think she'll be going back in front of her division judge to get a concurrent sentence. I'd ask you to leave the bonds in place.
okay, so the bond is $1,000,
Good luck, Lauren.
okay?
Thank you.
Sharon Sturgis.
North Broward.
Yes. Yes, Your Honor.
All right, good morning, Ms. Sturgis. You're before the court. Charge number one is felony violation of probation, which is a no bond hold. Count two is DUI, alcohol, or drugs. Count three is DUI with damage to property or person of another. And four is operating without a valid driver's license. Okay?
Yes, Your Honor, but I do have something that I believe is unfair. I gave my blood and everything when they took me into the Davie jail, and they told me it was under the legal limit.
Ms. Sturgis, I
Yes.
strongly advise you, as we talked about earlier, do not discuss your case at this time. You
Oh.
have a no bond hold from Judge Bailey. You have a court date tomorrow morning at 8:30. Judge Powell does not have the authority to change that no bond hold. Everything that you say here is being recorded and can be used against you later. So you don't even want to say anything that would even put you at the scene. Okay?
Yes,
So
sir.
you're going to have to go in front of Judge Bailey tomorrow. Judge, I'd ask you to leave the bonds on count two and count three in place so she can address those issues with Judge Bailey.
All right, so you do have a no bond hold, and as your attorney told you, you do have court tomorrow before your division judge, and the standard bonds are in place, okay? Valentina.
Good luck.
Blank.
Thank you.
Valentina Blank.
Approaching Judge here at Maine.
All right, Ms. Blank, you are before the court this morning. Charges number one and two are misdemeanor capias. Charge number one is a misdemeanor capias with a no bond hold. Number two is a capias with $1,000 bond. Charge number three is grand theft. Number 4 through 7 are felony capias matters. Those have no bond holds and are not for magistrate. And the court finds probable cause.
Thank you, Judge.
I'll leave the standard bonds in place on the no bond holds. Ms. Blank does have court tomorrow and the 12th and the 13th respectively. Okay? Michelle Parnell.
Ms. Parnell is here present, Judge at Maine, and she declined the services of public defender.
All right, Ms. Parnell, do you have a private attorney or plan on hiring one?
No.
Okay, well, this morning you're before the court for one count of abuse, child without great bodily harm, and the court finds probable cause, and I'll hear from the state in regards to bond.
Your Honor,
And if the main jail could please turn the microphone off, because we're hearing everything. Thank you.
as far as criminal history, she has theft priors out of the state of Delaware. My greater concern is the level of violence in this case, and also the fact that according to the detective, Ms. Parnell was interviewed by the same detective regarding a prior child abuse incident just months before this allegation, and was advised that she could not discipline her children in the manner that she apparently disciplined her child in this case. I'd be requesting a $5,000 bond and no victim contact, Your Honor.
Okay. All right, Ms. Parnell, is there anything you wish to say only in regards to setting your bond? If they could turn the microphone back on if she wishes to speak.
No.
Okay. All right, so at this time, I will impose a $5,000 bond, no victim contact until further order of the court. Okay?
Okay.
All right, where, David Early, is he at the main jail?
What page, Judge?
On page 21?
21? Oh, no, the cutoff is 16.
Yeah.
So let me see where it's at. David Early? Yeah, he would be here at main, Judge.
All right, so when he's available, if you can have him brought in the room, thank you.
Does he have his private attorney there?
Is there an attorney?
Detective.
Yeah.
Oh, detective, okay, all right. They're going to get him.
All right, Precious Dyer,
No problem, John.
North Broward.
okay? Ms. Dyer, you are before the court this morning for a grand theft charge. And the court finds probable cause. I'll hear from the parties.
Judge, I'm going to ask the court to consider releasing Miss Dyer on her own recognizance. She has been a lifelong resident of Florida. She has no prior criminal history. She does have family in the area. She's provided me with the phone number of her father. I've called her dad a couple of times earlier this morning and left messages for him. I have not heard back from him yet. She also has some medical issues that I believe would be best addressed outside of the confines of the Broward County Jail with her treating physician. In light of her ties to the community, lack of a prior criminal history, it's a nonviolent crime, I'd ask the court to consider an ROR.
Your Honor, my concern is despite all these ties, according to the probable cause affidavit in the booking sheet, her permanent address and local address is Sawgrass Mills.
Where would you be living if you were released, Miss Dyer?
I'm homeless. I'm gonna go home. I'm going home. I don't want to be in Broward no more. I'm going home.
Well, where is home?
Orlando, Orange County, ma'am.
Well, we have a Sawgrass Mills, and now she said address, and now she says she lives in Orlando. First, she said she was homeless.
But I recently had issues with cops being called on me. They told me if I didn't give them an address at that time, that I would be arrested. I gave them my job's old, where I used to work address. I don't have anywhere to go. I already told them I'm homeless.
All right, I'm gonna leave the bond at $1,000.
All right, I'm going to call your dad, Precious, and I'm going to try and get a hold of him to see if he can bond you out, all right?
All right.
Okay, good luck.
Shelmar Pickett.
She's a medical research on it.
Pickett is a medical reset. Andre Green.
She's here present, Judge at main. She is approaching. Come on up, ma'am.
Okay. All right, Ms. Green, you are before the court this morning for one count of grand theft,
Over $200,000.
first degree, and count number 2 is impersonating or using the ID of another person without consent. The court finds probable cause, and I'll hear from the parties.
Your Honor, I'm going to request that the court keep the bonds and release conditions that Judge Orlando set in place. It would appear, based on the allegations, that of the over $200,000 that Ms. Green stole from her employer, it would appear that about over $160,000 was in cash that does not appear to have been recovered.
Does Ms. Green have any priors?
No, Judge.
Okay.
Judge, as you heard, Ms. Green has no priors, never been arrested before. She has strong ties to this community. She is a registered voter here in Broward County. She is 52 years old. My understanding, Judge, is she is currently employed. She works as a property manager. She's been working here for about 4 months now. Her annual salary is about $45,000. So Judge, even if she had no expenditures or anything like that, she's safe for a whole entire year, not spending anything else, she couldn't come close to what the bond is currently set at. Now, she lives in Fort Lauderdale. She resides in a trailer where she owns. She's been there 7 years. Basically, it's a 30-year mortgage. She pays about $500 a month. So there's basically no equity in the trailer. Judge, she has property. She has one vehicle. It's a 2010 Hyundai with approximately 116,000 miles on it. She advised me probably resale value is probably about 5,000. I'm thinking that's probably on the high end. Now, she does have family that live in our community, specifically her sister and her mother. I believe her sister is a local school teacher. Her mother is works. But so she's going to try and reach out to her family to try and see if they can help her out with the bond. But she definitely knows 100% they cannot come up with $150,000. I'm going to be asking, considering her strong ties, she's never been arrested in her life. She is looking forward to having a day in court and contesting these allegations, and that's what they are. They're allegations, Judge. But I'm going to be asking if the court would consider a bond reduction of $10,000 on count one, $5,000 on count two, so a total of $15,000 on Miss Green's behalf, Judge.
And Your Honor, I would just state, first, I'm very concerned to hear that she's currently working as a property manager, considering some of these allegations, specifically that she created a separate company and fraudulently advised renters to send their rent checks payable to that company instead of her employer, subverting money from his business. Additionally, Your Honor, as far as the financial resources that Mr. Romero advised the court of, I don't know how much weight that can be given considering the sheer amount of cash that was stolen in this matter.
All right, you are correct that these are allegations, but these are the allegations that this court has before it this morning to make probable cause finding and for bond consideration. And these allegations are that Ms. Green cash checks in the total amount of $164,000, $443.47. That's through cashing checks, and then through using credit cards to the total amount of $46,663.16, and then other payments, making other payments through the company's credit cards. And so based on those allegations, the court does find probable cause. I am going to impose a bond of $50,000 on count one and $50,000 on count two. And that is also going to include all the other special conditions that were attached to the warrant for arrest. Okay?
Your Honor, the only thing I would ask,
Yes.
directing the court's attention to the bond order
Yes.
that Judge Orlando wrote. He put the bond amounts on there. Would the court have any issues with changing count one to $50,000? And then on the special condition number 6, there's still a blank there, so I guess that would be $100,000.
Parties agree the defendant submitted only after the court's ruling that the answer would be so close. Okay, so I'll make those changes, 50,000 on count one. And then it's a total of 100,000.
Thank you, Judge.
Okay. Ismore Sanchez.
Ms. Sanchez, come on up, please. She's here at Main, approaching.
All right, Ms. Sanchez is before the court. Count one is a misdemeanor KPS. Count two is a misdemeanor KPS. 3 through 11 are felony out-of-county holds. And those are not for magistrate, and those all have bonds attached to them. The court finds probable cause on the misdemeanor matters. Ms. Sanchez does have court on the 13th at 9:30. And just for her information, the out-of-county holds are out of St. Lucie County and St. Martin. Okay?
Judge, in speaking, Ms. Sanchez, we did talk about the out-of-county holds, that there's nothing this court could do, and it's not even for magistrate. However, the two misdemeanor offenses that are here in Broward County, the cannabis and the resisting without violence, she's wondering if the state has a plea offer for those two offenses.
There would be a withholding court cost on one, adjudication time served on two.
Judge, she wishes to accept the state's offer on those two.
Okay, Ms. Sanchez, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. And Ms. Sanchez, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case? Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
And do you understand that you do have the right to go to trial, but by taking a plea today, you are giving up that right?
Oh, I'm sorry.
And, ma'am, have you ever been treated for mental or emotional illness?
Yes.
And is there anything about that treatment that would prevent you from making an intelligent decision today?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yeah.
What plea do you wish to enter?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Count one, your sentence is withhold adjudication and court costs. Count two, it's adjudication and time served. Good luck. All right, on page 8, Mr. Romero, do we have Stanley Walker?
Yes, he's here, Judge. Come on up, Mr. Walker.
Good morning, James. If, Mr. Walker is before the court this morning for aggravated battery with a deadly weapon. It's domestic violence. And the court finds probable cause. And I'll hear from the parties.
And I was sitting here by his mother. From my understanding, it's a family dispute. She has limited funds. Another sister is supposed to be moving out, so he does have a place to come back to at the bonding posted bond.
Okay.
It also would appear from a reading of the probable cause affidavit that the victim is the one who initiated the contact here. According to the report, she's told the defendant, fight me, and swung a closed fist at the defendant in an attempt to punch him. It was at that point, according to the victim, that Mr. Walker goes to his vehicle and grabs this metal bar, which ended up cutting her wrist. But Mr. Walker gives a statement stating that her friend, the victim's friend, Gerard Ware, jumped on him and that Sharon hit him with a bat. And the report also does indicate that Mr. Walker had a knot on his head. And claims that the reason he had the item that was struck, used to strike the victim, was in self-defense. So I understand the court finding probable cause, but I have a feeling there's a lot more than meets the eye in this case.
Okay. State.
Your Honor, the state would be requesting a $7,500 bond and no victim contact. Mr. Walker in 2009 was arrested for domestic violence, felony battery, great bodily harm, and felony battery due to prior convictions. Those charges were dropped. In 2008, he was arrested for domestic violence battery. That was dropped. 2007, resisting without violence. 2002, possession of controlled substance with intent to sell or distribute within a specified area, 2.5 years state prison. 2002, possession, same offense, 2.5 years state prison. Traffic, fleeing and eluding, and assault in 96. Battery conviction, 96. 95, aggravated battery against a pregnant victim with a violation of probation, 90 months state prison. 95, burglary of a dwelling, VOP, 90 months Florida state prison.
James, did the parents or whoever hired you say how much bond they can afford?
I think it was 2,500.
All right, so I'm gonna set the bond at 2,500. No victim contact. until further order of the court.
And Judge, the only request we're gonna have is a photo order so we can photograph the injuries that he sustained to his head.
Okay.
Thank you.
All right. Carmelita Prudhomme, she here today?
No, she's set, Your Honor.
Medical reset.
I'd ask the court to make a probable cause determination.
Did we do that?
As long as we bring her back for bond, I don't mind.
Okay, all right, so we'll make a probable cause, finding, and then Ms. Prudhomme, when she's available, we'll come back to talk about bond, okay? And how about Merica Patterson?
Medical reset also.
And again, I'd ask the court to make a probable cause determination.
Same request from the
All
defense.
right, so we'll make a probable cause, determination. And Patricia Burdick,
Withdraw.
Right. Good morning.
good morning, Ms. Burdick. You're before the court this morning. Charge number 1 is battery on an officer or firefighter. Count 2 is aggravated assault on an officer or firefighter. Count 3 is resisting officer without violence.
Yes, Judge, I've been trying to reach Miss Burdick's husband.
I believe
Unfortunately,
there's a gentleman behind you raising his hand.
okay. Yeah, I left you a couple of messages, but, all right, well, he's here, Judge, so do you want to step up to the podium?
Good morning, sir. All right. Is there something you wanted to let me know?
Yeah, she was in the middle of trying to commit suicide when she was arrested. She was intoxicated. I don't think she had any clue what happened. I talked to her after the event, and she doesn't remember anything about that evening. This is
Okay.
not her typical behavior. She's been having some problems lately. We've been trying to get her help. But I don't think the legal system really what's going to help.
Did you try to have her taken to a hospital?
Tried to bring her to Henderson. We made an
Or
appointment.
Baker, oh, to be,
And then we also tried to go to a private psychiatrist, and she missed the appointment. That was last Friday.
okay. So, I know you're here today, and I know we have the situation before us. Are you able to post her bond?
I'm
How much bond can you afford?
probably about $1,000 to $1,500.
Okay. All right, State?
Your Honor, there's other issues going on right now. I'm not sure why Ms. Burdick was at this residence to begin with. Ms. Burdick was arrested June 1st of this year for domestic violence battery against Mr. Dolce, where a no victim contact order was issued. This is, that arrest came, let's see, about 3 weeks after she was arrested for a previous battery against him. That ended up getting dropped about a week before the new arrest. And in that matter, the most recent matter, she's accused of biting him on his right shoulder.
It's my understanding from speaking with Miss Burdick that she and her husband are working to get that case dropped.
Well,
They're not supposed to be working on
there's a
anything
no contact
together.
order in place, so,
Well, they're working separately.
Your Honor, I'm gonna, first I would note on count two reads to me as an assault on a law enforcement officer.
Yeah, I think so.
On count one, Your Honor, considering this is her third arrest in about a month, all alleging violence, I'd be requesting a $2,500 bond.
okay.
That's fine, Judge.
Yeah, well then, count 2 is assault, okay.
Yes.
And, Your Honor, I would also be requesting a pretrial with random drug testing.
That's fine also, Judge.
All right. So on count one, I'll impose a $2,500 bond, and that's also going to be with pretrial supervision and random drug testing. Okay? And,
I know, I already talked to her about it too. And just so the record's clear, Judge, I did speak to Ms. Burdick about the importance of the no contact order that was issued previously, and that she is not to have any contact with Mr. Burdick. And, you know, I'm sure you appreciate the severity of that as well. And then one of the big problems is that she violates that order, it demonstrates to the court that she's incapable of following court orders. And that's not a very helpful fact when it comes to getting bonds. So no contact between the two of you, okay?
all right, thank you.
Thank you, Judge. What about count two, Judge?
2,500. I thought count two is, no, is now a misdemeanor.
Yes, ma'am.
So I'm not, no, right, no charge. Okay? All right. Roy Williams.
Mr. Williams is present here at Maine. He's approaching. Come on up, Mr. Williams.
Mr. Williams is before the court on one charge of domestic battery by strangulation, and the court finds probable cause.
Your Honor, I'm going to be requesting a $15,000 bond, no victim contact, pretrial release of the GPS monitor. Mr. Williams was arrested last year for aggravated battery against a pregnant victim and domestic violence battery by strangulation against the same alleged victim. The charge was dropped January 28th of this year.
Okay?
Judge, as you just heard, he basically has a clean record. He's 30 years old. He's been living in our community now for about 6 years. He is working. He works at a company called M-Lot Tires. He's been employed there for 5 years and gets a weekly paycheck at about $500 per week. Now, he lives separately from the alleged victim. He lives with his sister. His sister, basically her financial resources are quite limited. She's basically a stay-at-home mother. The only person that could potentially post his monetary bond, he gave me the phone number of his employer, who I intend on calling him, but he's not sure how much he can afford if he's even going to be in a position to post his bond. But definitely, Mr. Williams did tell me that he's not going to be able to afford the $15,000. We're going to be asking, considering his clean record, we're asking for the court to consider a $3,500 bond on Mr. Williams' behalf.
All right, the court imposes a $10,000 bond, no victim contact, until further order of the court. All right,
The main jail has Mr. Early, Your Honor.
Yes, Judge, we're ready to proceed on Mr. Early. He is on page 21.
all right. All right, David Early. Mr. Early, you're before the court this morning. Charge number one is burglary, occupied dwelling unarmed. Count two is grand theft auto. And the court finds probable cause. And I'll hear from your attorney.
Your Honor, the state would be seeking a $25,000 bond on count one, a $5,000 bond on count two, no victim contact, no return to this residence, pretrial release of the GPS monitor. I would note, I am concerned that this burglary occurred breaking into, unlawfully entering someone's garage while the residents were present, breaking into their vehicle. Mr. Early was found in possession of the stolen property from the vehicle in the garage. Additionally, Mr. Early is out on bond right now for possession of substituted cathinones and misdemeanor possession of cannabis. It's a 2018 case. I believe he was released from custody, I believe March of this year. He had his bond revoked in that matter based on a new arrest. That case was no info, so he was released on a $1,000 bond on each count. Additionally, in 2010, he had a robbery with a firearm or deadly weapon. 07, a burglary of a dwelling, and he violated probation. On each of those cases, he was sentenced to 7 years from Florida State Prison. He was released from Florida State Prison most recently, May 11th, 2017. Your Honor, I would just also note for the record that Detective Merrill, the Broward Sheriff's Office Burglary Apprehension Team, is present in court. I believe there are law enforcement concerns as well. I don't know if Detective Merrill wishes to advise the court of any concerns.
Morning, Detective.
Morning, Your Honor. We received information of a burglary crew that was involved targeting occupied houses where they locate garages that are open, enter the garage, and steal the vehicles.
Judge, I'm going to have to object to this line of testimony from the detective. Unless there is evidence before this court that Mr. Early is involved in any of these other crimes, and there's no mention of that, any evidence to support it in the probable cause affidavit, then it's not relevant to this court's determination as to what bond is appropriate in this particular case for these particular crimes that are in front of the judge.
Your Honor, all he's testified to is information he received that led to their investigation.
And are these, the information that you're giving me, does that relate to Mr. Early?
Yes.
Is there a connection that you're aware of to Mr. Early?
Yes.
Okay.
The vehicle that he's been driving has been seen in the area in multiple other burglaries where these vehicles were targeted. And in this incident, the vehicle was actually seen passing the house before stealing the Range Rover. And then once we continued our surveillance, we observed Mr. Early in the stolen Range Rover at a gas station. Mr. Early was observed going from the Nissan into the Range Rover, going inside of it, actually going through the glove box, going inside of it, and they started wiping down the Range Rover. Mr. Early returned to his vehicle and his Nissan, and his co-defendant took off in the Range Rover.
Okay.
And once Mr. Early was found, he was subsequently had property from the actual burglary that took place in Southwest Ranches.
Okay. All right. Mr. Romero, is there anything you wish to say?
I do, Judge. Mr. Early is clearly going to be contesting. He's disputing all the allegations that were mentioned from the state. Judge, from speaking to Mr. Early, he's 29 years old, his whole entire life. He works in landscaping. He's been employed with that same company for about 1 year. He just mentioned to me he works 6 days a week, making approximately $70 per day. Now, he does live in Fort Lauderdale, so he lives here locally. He lives with his mother, and they've been residing at the same location for about 6 years. My understanding, Judge, Mr. Early does not have any property, but he did tell me that he has $100 in his bank account. So that's all he really has access to. So he's going to be dependent on his mother to help him financially. Now, she is working. She works in data entry. But that's the person that he's going to be contacting on poster bond. Now, I do realize that the state did mention that he's currently out on a drug offense. I believe it was a 2017 case. He's had a number of court appearances on it. He has the Office of Public Defender representing him on that, and I believe, from what Mr. Early advised me, they're ready to present some motion to be heard, I believe, in front of his Judge Shear. I'd ask you at this time for the court not to take any action on that open case, but if the court is inclined to do so, I'd ask the court to consider standard pretrial release on that case. On this case, Judge, my understanding, and speaking with Mr. Early, he believes that if the court were inclined to set somewhere in the neighborhood about a $5,000 bond on count one, that his mom may be able to afford that. So we're requesting a $6,000 bond on Early's behalf, Judge.
All right, at this time, the court does have cause for concern for the community. The allegations of entering into person's garage while they're at home, opening the garage, removing the car, is a cause for concern for the community. So at this time, I am going to impose on count one, a $25,000 bond. And on count two, I'm going to increase the bond to $5,000. No return to this location, no victim contact. And if Mr. Early's post his bond, he will also be on a level 2 GPS. Okay. All right, Mr. Plant? All right, on page 9, we have Tendai Morape.
He's approaching, Judge. He's here, man.
Okay. All right, Mr. Morape is before the court again for a municipal ordinance violation. And at this time, Mr. Morape has been before this court several times this year. I am going to leave the bond in place, and so he can go to his division.
Yes, Judge.
All right, Roger Lineger on page 10. All right, Mr. Morape, that's it. I find probable cause and you have a bond. Roger Lineger?
Lineger?
Yes. Page 10.
Roger Lineger?
Yes.
The main.
Roger Lineger, not Roger Lineger. Lineger? Yes. Roger? No. Yes. From the judge, man. Oh, bitch. You gonna get your name perfect? You gotta say the name right, now I'm understanding. Okay, when they call you police, that's the same thing.
All right, sir, I guess there's an issue with your last name. What's your last name? Who do we have standing at the podium?
Roger Lineger.
Sir, can you hear me?
Come on, man. Talking to you, man.
Well, you were responding before when I called your name, so why can't you hear me now?
I'm having understanding.
Really?
Yes.
You were talking up a storm before you got to the podium. So, how do you spell your last name? Because I have your last name as Liniger. So, how do you spell your last name?
No, Linenger.
Now you hear me. Okay. So, you are
I get
yeah, so you're before the court today for 2 counts of municipal ordinance violations. What do you wish to do today, sir?
I have a hard time hearing you. I'm sorry.
All right, Mr. Lineger, I find probable cause. He has a bond of $25. Okay?
Judge, have a seat. Judge.
Sorry?
Have a seat.
All right. On page 11, Travis Taylor.
Good morning, Your Honor.
Good morning.
Good morning, Mr. Taylor. You're before the court today for 2 misdemeanor KPS. Both are trespassing charges.
Yes, ma'am.
What do you wish to do today, Mr. Taylor?
I would like to resolve those, ma'am.
All right, Mr. Taylor, please raise your right hand. Your sentence will be adjudication and time served.
Yes, ma'am.
Okay, do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Taylor, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
And sir, do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, sir?
No contest, ma'am.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck.
Thank you very much.
That's it. That's Mr. Chairman. And then William McDonald on page 11.
Good morning,
Where's Mr.? Okay, good morning, sir. You're before the court for a county ordinance violation, and the court finds probable cause. What do you wish to do, sir?
I'd like to resolve the case today, if that's possible.
All right, sir. The sentence will be adjudication and time served if you'll raise your right hand. Do you swear or affirm to tell the truth?
Yes, I do.
You can put your hand down. And sir, do you understand everything that's going on here today?
Yes, I do, Your
Is
Honor.
anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, I'm not.
And do you need any more time to speak with your attorney?
No, thank you.
And sir, you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
I do.
And have you ever been treated for mental or emotional illness?
No.
And sir, do you understand that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, I understand that.
What plea do you wish to enter, sir?
I'd like to plead no contest.
Okay, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir.
Thank you, man. Have a nice day.
You too. William Reyes on page 13.
He's here, present, Judge.
All right, Mr. Reyes is before the court for disorderly conduct. And the court finds probable cause. And what does Mr. Reyes wish to do?
Judge is speaking, Mr. Reyes. He wishes to resolve this matter.
One moment, Judge.
Okay. It's a county ordinance, Broward County.
Oh, it's a
It's
county
a
ordinance?
state, it's a state charge.
Yeah, oh, okay. Oh, no, yes, I was looking at the other one.
County.
Yes,
County charge.
Just need to check something that happened on a case of his on Friday. Your Honor, based on the totality of the circumstances, state's offer would be 5 days in county jail. Well, the reason being, he was just released from jail last Friday, June 7th, after he pled to a domestic violence battery, resisting without violence, domestic violence battery and resisting without violence.
okay. All right, and also, just based on the allegations that we have here in this probable cause affidavit, I think 5 days is a reasonable sentence at this time.
Judge, I just spoke to Mr. Reyes. I just relayed the state's plea offer, and I understand that he was released on another incident. However, on this separate charge, nothing to do with that, my understanding is basically he suffered from a heart attack. That's why he was there at the hospital. My understanding, Judge, is when they were trying to attend to him, they were trying to, I believe, draw blood. It didn't go well. His veins, from my understanding, they have a hard time. They were just puncturing him. He just needed a break, and he wanted to step outside. And he came in contact with a law enforcement officer. My understanding is he tried to explain to the law enforcement officer what happened, and from there things escalated. Having said that, Judge, he's from New York. He's here on vacation. He doesn't have the $25 to post bond. My understanding is he's
Niagara Falls, Canada funds.
Judge, from what he said, advised me, the monetary, I guess it's, he doesn't have the ability to post a bond here at the jail, Judge. But he's advised me that he has help.
He's on vacation, but he was just released from jail on June 7th on another arrest.
Yes, Judge.
All right, I'm gonna leave the bond in place, at this time, okay? All right,
Just one on page 9, Your Honor,
right, which one?
on the top. Aaron Michelson, he's at Maine.
Okay.
Michelson.
Resolve this right now.
Judge, he wants to address.
I want to resolve this case, Your Honor. You know, like, I'm here, I had a heart attack. I need a medical issue. Like, I'm here for a certain reason. It's not like I committed an actual crime. I wasn't under arrest at the time. I was there getting help for medical, a heart attack. You know what I'm saying? Like, I didn't commit no crime whatsoever. Like, there's cameras, there's videos and all that. The only reason why I'm trying to plead content right now is so I could go to the hospital. That's the only reason why. I'm not trying to fight no case. I'm not even supposed to be here, Your Honor, whatsoever. I'm actually hurt right now. Like, I really am, Your Honor. And I am here on vacation. And the reason why I can't pose with $25 is I don't have US dollars. I have Niagara Falls, Canada money. So they won't allow me to cash money out whatsoever. I tried to bond out yesterday with my credit card, ma'am, and they won't allow me. They're saying that because of the funds. It's not that I don't have the money. It's that I don't have US dollars, ma'am.
Well, what I don't understand, sir, and you were recently released from custody for another charge, so I don't understand. And now I have this police report that says that the medical staff at the hospital requested law enforcement because you were being unruly. And when the officer arrived, you were cursing and yelling at the staff. And the officer told you that if you wanted to be treated, you had to remain at the bedside. You continued to yell. And then when the officer told you that you said you wanted to leave and the officer told you could leave, you got in the officer's face and told him that I'm about to show you what's real. And the officer took this as a threat and pushed you out of his face. So there's a lot that's going on here that does make sense.
Sir, if I may?
Yes.
I just want to read to you from his report, May 5th. That was the domestic violence battery arrest. Officer responded to a domestic disturbance.
The arrest was May 5th from the other?
Yes.
All right. The bond is $25, okay? Aaron Michelson.
Yelling profanities at the hotel manager. Officer asked him to remove his
All right, Mr. Michelson's bond has been posted, okay? All right, I have two people here who signed in on the sign-in sheet. Rebecca Stewart and Topaz Baker. Okay, you've signed in, but for persons who are not on the docket. So how can I help you today?
What's her name? Topaz
The
Baker?
defendant's name, is this Luke Igito? Well, who signed in on the other person?
Oh, maybe her friend. Her friend is here also, so I think she signed.
Ms. Baker's not going to come through the division. She's being held on out-of-county holds out of Duval County.
Okay, well, that person is not here right now. And then the other person is Luke Igito? Which one is your, ma'am, what's your name?
I'm Topaz Baker,
And so you're here for Danielle Baker.
which is my daughter.
Okay, and she's not on my docket today. Okay?
She's not gonna come through here.
And she's not gonna come through here because,
She's got an out-of-county hold out of Duval County, that's all she's being held on.
okay?
So just to make sure I understand, so she's not gonna have a hearing here in Broward at all?
No. This is first appearance court.
Right.
And so people who are arrested within 24 hours, they have to be brought here for a bond to be set. She's being held on an out-of-county hold. When was she taken into custody?
I think it was Monday morning, like around 2:30 in the morning.
Yeah, I mean, it's
How much are the bonds?
45,000.
So Duval County has a $45,000 bond.
Okay, so that was my reasoning for coming here, to see if there's any way that I can beg to have it lowered due to the fact.
It's not a bond from Broward. It's
Oh.
a Duval County bond.
So I will have to
so
go
there's
there.
So there's nothing that Broward County can do about that bond.
Oh, so
Right.
I have to go up, call and find out and go up
Right.
there to
You have
request
to
it?
find out up there.
Okay,
Okay?
all right, thank you.
All right, no problem. All right, and then, who's Rebecca Stewart? All right, that person's not here. All right? Okay, let's continue with our docket then. Jeffrey Luthridge.
Mr. Lutheridge is approaching.
All right, Mr. Luthridge is before the court on 4 counts of misdemeanor capias. Mr. Plant left, some of them are municipal ordinance violations and some are state charges.
And one's a ordinance.
If Mr. Lutheridge wants to resolve the matters, I can offer adjudication time served on counts 3 and 4.
Okay,
He wishes to.
No contest.
all right, so,
He's eager.
so Mr. Luthridge, it's from one extreme to the next. But if Mr. Luthridge wishes to resolve the cases, then it'll be adjudication time served on all the counts. And so, Mr. Luthridge, you understand?
He understands, Judge, and he wishes to accept the court.
All right, Mr. Luthridge, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Absolutely.
You can put your hand down. And sir, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
Not at all.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No.
And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Mr. Luthridge?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir. Mark Orphan.
He's approaching, Judge.
All right, Mr. Orphan is before the court for its panhandling, and the court finds probable cause.
And Judge, he wishes to resolve this matter today.
All right.
Anything out of state? Just let me. Just going through his history, briefly.
That's my son right there.
Okay, Your Honor, the offer is adjudication time served.
He wishes to accept the state's offer, Judge.
Okay. Did you say adjudication and time served?
Yes, ma'am.
All right, Mr. Orphan, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
And Mr. Orphan, you can put your hand down. Do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And, sir, do you need any more time to speak with your attorney?
No.
And have you ever been treated for mental or emotional illness?
No.
And do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Do you understand, sir, that if you're not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, sir?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck, sir. James Cardell.
Mr. Cardell, come on up, please.
Your Honor.
Mr. Cardell, good morning. You're before the court for one count of trespassing, and the court finds probable cause.
Judge, and speaking Mr. Cardell, he wishes to resolve this matter today.
All right?
Your Honor,
Yes.
Mr. Cardell is currently on pretrial supervision in case number 189100CF10A, uttering a forged instrument, grand theft in the third degree, possess unlawfully issued driver's license, forged counterfeit credit card. He was released on pretrial April 25th, 2019. At this time, we're requesting a revocation of his supervision.
All right.
Judge, if I heard correctly, is Mr. Cardell out on a felony offense on pretrial?
Yes.
I was just.
And Your Honor, just to advise the court, he's out on bond and pretrial. Guys.
Oh, this
Looks-
is bond and pretrial?
Yeah, what happened was on that case, Judge Garcia Wood issued a no bond capias for a failure to appear. The defense filed a motion to have a bond set. Judge Garcia Wood granted it, set bond at $750 on each count. Looks like total bond of $2,500 plus standard pretrial, and he went through a bondsman to post the bond.
Judge, considering he's out on pretrial, I'm going to be asking the court not to take any action. Speaking to Mr. Cardell, my understanding is it was a situation in which normally he wouldn't do this. It was raining. He was simply passing by. It's not like he went purposely to that location to try and, don't say anything, let me say, to try and, go back to that location. It was something because of the weather that he was forced into that situation. I did not know he was out on the case. At this time, Judge, I'm asking you not to take any action on it. And that's all I can ask at this time, Judge. I've got.
So it started out that he was on a no bond capias, is that correct?
Yes, Your Honor.
And then he goes to court and the judge gives him a bond and put him on pretrial.
One moment, Your Honor. Let me just check something. I just want to. Yes, it was a no bond capias for failing to appear at a calendar call on March 7th.
All right, so, based on that information on case number 189100CF, well, all right. On the case number 189100CF10A, this court will not take any action this morning on the pretrial. And his bond on the new arrest, I'm going to increase to $500. Okay? All right, Ivan Lopez.
Mr. Lopez is approaching, Judge.
Mr. Lopez is before the court. Oh, I'm sorry.
He's approaching, Judge.
All right, Mr. Lopez is before the court. Charge number 1 is DUI, alcohol, or drugs. Counts 2, 3, and 4 are DUI with damage to property. Counts 5 and 6 leaving the scene of a crash involving damage to property. And the court finds probable cause, and I'll hear from the parties as to why.
Judge, nothing to add at this time. I'm going to be contacting his girlfriend to see if she can post his monetary bond.
Nothing from the state.
All right, so the standard bonds are in place.
I'll call over as soon as I get out of here.
Eric, let's go.
Mr. Hopefully Olga can come up with it. I'm calling you. She's got the cash. Okay.
All right, Mr. Glasgow is before the court on 2 misdemeanor KPS. It's municipal ordinance. Mr. Glasgow, what do you wish to do today, sir?
No contest.
All right. All right, Mr. Glasgow, I'll accept your no contest plea and sentence you to adjudication and time served. Good luck, sir. Okay?
Thank you.
All right, Michael Gallo.
He's approaching, Judge. He's here at me.
All right, Mr. Gallo is before the court on 2 misdemeanor capuses. One's a state charge, one's a municipal ordinance violation. What does Mr. Gallo wish to do?
Judge, he wishes to resolve this matter today.
All right. State, did you have an offer for Mr. Gallo?
Yes, Judge, it'd be time served.
All right.
He wishes to accept the state's offer, Judge.
Mr. Gallo, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Gallo, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And sir, do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes, ma'am.
And sir, have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Gallo?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, sir. Christopher Saunders.
He's approaching, Judge. Is your presence?
All right, Mr. Saunders is before the court. There's a misdemeanor capias. The charge is petty theft. And it looks like Mr. Saunders, this is an old capias, did not show up for a hearing November 27th of 2017. What does Mr. Saunders wish to do?
Judge, considering this is a 2016 petty theft, I did speak to Mr. Saunders. He wishes to resolve the matter.
One moment, Judge.
Okay.
Offered be adjudication, time served.
Judge, I don't know if this is true. I don't know if Mr. Lunder can verify. I don't believe he has an extensive record dealing with thefts. If he doesn't, considering it's a 2016 offense, would the court be inclined to offer a withhold?
He had 2 previous thefts I saw that were withholds, numerous thefts that were dismissed.
All right.
You'll accept the time served, Judge.
All right, Mr. Saunders, please raise your right hand.
Actually, Your Honor, I'm
Yes.
sorry. I just checked this case. The court should be advised, and this capias was issued by Judge Lerner Wren, and it makes sense considering how many of his prior thefts were dismissed.
So is the Judge
I
Lerner?
I understand that, then I don't feel comfortable in resolving this matter, having been enlightened with that information. I'm gonna ask the court, considering this is a 2016 nonviolent offense, would the court consider an ROR on Mr. Saunders' behalf?
Is the case, well, it was issued by Judge Lerner Rent, but it's not in Judge Lerner Rent's division based on the case number, or is that not correct?
No, it's in,
It's
it was transferred there. It was
Okay.
originally before Judge Schiff. No, I could text her judicial assistant, and I'm sure they'll get in before Judge Leonard as quickly as possible, but, I mean, this has been a capias from late November 2017. If there's help he needs, I think
Can we get him in tomorrow?
I'll text her right now.
All right. If we can get him in tomorrow. So let's, we'll check. If we can get him in tomorrow, then I'll leave him on, so that he'll be in tomorrow, okay?
Brief recall then?
Yeah, just brief recall, okay? Xavier Holcomb,
He bonded, Judge.
okay? Carl Wiggins,
He's here, Mr. Wiggins.
all right, Mr. Wiggins is before the court on a misdemeanor capias for a battery charge. It looks like Mr. Wiggins missed court on May 9th of 2019. And there's a bond in place for $1,000, and he also has court tomorrow before his division judge. So,
Nothing to add, Judge.
all right. So, ma'am, were you here on that case? Okay, so he has court tomorrow before his division judge at 9 a.m., okay? Do we know, who the judge is? And that's courtroom. Do you need your paperwork back? Okay. Well, if, that's up to you. You can post the bond. Or you can go to court tomorrow if I don't know if he can resolve his case tomorrow, okay? 5160? Okay. Judge. I can't give you any advice, okay? All right. Talk to Devin Roberts.
Devin Roberts is here at Main Judge approaching. Come on up, sir.
This guy bonded?
Mr. Roberts is before the court for charge number 1 is criminal mischief, and 2 is resisting officer without violence. And the court finds probable cause.
Judge, I realize that the bond is only $100, but Mr. Roberts advised me he doesn't have it. He's homeless. He's been homeless now for about 1 month. He's 26 years old, been here his whole entire life. He just got a job. He works at a place called Fish Windows Cleaning Service, where he's been employed there now for about 3 months, and he's hoping that job will, he'll be able to afford housing. Judge, but right now there's nothing he can afford, so he's asking if the court would consider releasing him on pretrial release.
Your Honor, Mr. Roberts was arrested. Actually, he was arrested January 4th of this year for domestic violence battery against the same alleged victim. He posted a $500 bond, was released January 17th. He was then arrested April 2nd for a capias on that battery, posted a $2,000 bond, and the case was just dropped about a little under 2 weeks ago. It's, as I mentioned, the same victim is in this case.
All right. Okay, Mr. Romero, what were you asking for?
We were asking for pretrial release considering right now he's homeless and nobody can post his bond, Judge.
And Your Honor, because it involves the same victim, I'd be requesting a $500 bond on count one in order of no victim contact.
Yeah, I'm gonna leave the bond in place, okay? And no victim contact. Keon Bolden,
Judge, before we leave Mr. Roberts' case, I noticed that a lot of his prior matters were heard by Judge Lerner Wren. So it might not be a bad idea to see if we can get Mr. Roberts in front of Judge Lerner Wren.
okay, I have no problem doing that.
Well, I can tell you the most recent case from just a few months ago was in front of Judge McHugh the entire time, but.
But the one, the 2019 case is Judge Lerner Wren.
Okay.
He had a traffic citation in 2018 in front of Judge Lerner Wren.
Those were in her MS division.
Are those in her regular division?
Yeah, they weren't. This case is assigned to her MS division. It's not mental health.
Okay.
Okay, all right, never mind then, Judge.
Okay. Keon Bolden,
Bonded, Judge?
bonded. Deshaun Murphy,
He's approaching, Judge.
all right, Mr. Murphy's before the court, is this an at charge?
Yes, ma'am.
Robbery by sudden snatching without a firearm, and the court finds probable cause.
Judge, my understanding is he's sentenced on a case till September 25th. So no matter what happens, he's not going to be released earlier. Till then, he'll probably get a court date in front of his division judge. So at this time, nothing to add from the defense, Judge.
All right,
Your Honor, I'd request a $2,500 bond.
all right. I impose a $2,500 bond, okay? Eugene Ritfeld?
Judge, Mr. Murphy wanted to know I apologize. Date of incident on this act charge of robbery by sudden snatching. He doesn't know anything about it, and he wanted me to request a $1,000 bond on the 30th.
All right, this is April 1st of 2018.
And
At Simon's Sportswear in
Your Honor,
Hallandale, yes?
the reason I requested a $2,500 bond, the cases he's county sentenced on, aggravated battery, grand theft, another battery, and he has a pending grand theft.
Okay. All right, I'll leave the bond in place at 2,500. Eugene Ritfeld,
Medical research, Your Honor.
okay, medical reset. Desir Hendrick,
Mr. Hendrick? Desir Hendrick? He's approaching, Judge.
Medical reset.
or Mr. Hendrick is before the court for a petty theft charge. The court finds probable cause.
Judge, nothing to add at this time.
Does the suspect?
All right. He does have a bond of $750 and no return to the public's in Pompano Beach, okay? Brandon Rogers. All right, Mr. Rogers, charge number 1 is panhandling, and then 2 and 3 are felony capias, though both with no bond holds. So the court finds probable cause. He does have a $25 bond on count 1, and he will appear before his division judge tomorrow at 8:30. Okay? Joseph Gilead.
He's approaching, Judge, here at Maine.
All right, sir, you're before the court for one count of grand theft, and count two is dealing in stolen property. And the court finds probable cause.
Judge, in speaking to Mr. Gilead, he's not going to be able to afford to post the monetary bond at this time. My understanding, Judge, is he has a clean record. He's a registered voter. He lives in Boca Raton with his parents. From what he advised me, his parents have medical issues, and they're not going to be able to come and post his bond. He's 46 years old, been living basically in South Florida almost all of his life. He just got employed 1 week ago at a security job where he's going to be making $11 an hour. I don't even think he's received his first paycheck yet. But he's asking on these nonviolent offenses if the court would consider releasing him on pretrial release.
Okay, I'll hear from the state.
One moment, Your Honor. All right, thanks. Yeah, I have no objection to pretrial, Your Honor.
All right. So release Mr. Gilead to pretrial supervision. The attorney will give you the address and the directions to the pretrial office. Sir, you must report within 24 hours of your release. If you don't report, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am, thank you.
Okay, good luck. Timothy Ryan.
North Broward.
Yes, Your Honor.
All right, Mr. Ryan has counts 1, 2, and 3 are misdemeanor capuses, and then 4 is a felony capus with a no bond hold. So Mr. Ryan will be before his division judge tomorrow at 8:30, and the standard bonds on the misdemeanor cases, there's $50 each, will remain.
Judge, Mr. Ryan did indicate or express an interest to me that he might want to resolve those municipal ordinance cases.
Okay,
It's a violation of pretrial release, and
which one?
count 4. And from what he tells me, that the municipal ordinance violations, cases will not violate his
Oh,
pretrial release.
I see. All right, so Mr. Ryan, if you want to resolve the municipal ordinance violations, there's open containers and unlawful assemblies.
I was sitting on the sidewalk.
You don't need to explain, Mr. Ryan.
Having a heart attack, that's
Mr. Ryan,
why I was sitting.
Mr. Ryan,
Well,
listen to what
I'd
the
like
judge,
I'd like it on the record.
listen to what the judge has to say,
It's my
Mr.
court
Ryan.
date, and I have a felony because I was having an open heart surgery. So it is relevant to the case.
Well, then if that's the case, then you don't want to resolve the cases, then you have
No,
a
I want to
defense.
resolve the case. I just
No.
want to know, explain why I had the municipal unauthorized assembly,
All
which
right.
was sitting on the sidewalk having a heart attack.
I'm not gonna resolve the case today. If you have a defense, this is only first
No,
appearance.
not a defense, ma'am.
Okay, sir,
Ma'am,
we're
an
done.
explanation.
We're done. Anthony Reeves?
Show me.
He's here, President Judge May.
All right, Mr. Reeves is before the court this morning. 1 and 2 are traffic capias. And count 3 is carjacking with firearm or weapon. And the court finds probable cause.
Your Honor, the state would be seeking a no bond hold on count 3 upon a finding of proof evident or presumption great, relying upon the arrest warrant affidavit authored by Detective Michael Bullzone of the Sunrise Police Department.
And at this time, Your Honor, we would object to the court making a finding of proof evident presumption great. That is the highest standard of proof that we have in the criminal justice system, higher even than proof beyond a reasonable doubt. It does appear from reading the documents generated, the warrant and so forth, that Mr. Reeves and the alleged victim in the case knew each other and were at one point, it appears, friends. So who knows, there might be another side to this story, quite easily could be. In any event, the state has not introduced any photo lineup that the alleged victim used to identify Mr. Reeves. They've not introduced any statements made by the alleged victim in the case. In fact, they have introduced no photographs of the alleged injuries sustained by the victim in the case. They have introduced nothing. So at this point in time, the defense's position is that the state has failed to meet the very high standard of proof evident presumption great, and we would ask the court to set bond for Mr. Reeves in this matter. If, over our objection, the court does find that proof evident presumption great has been established, we would urge the court to exercise its discretion and set bond for Mr. Reeves.
All right, the court, after reviewing this, the affidavits to arrest that has been presented to the court does find probable cause and will make a further finding of proof evident presumption great. And Mr. Reeves will be held no bond until further order of the court. This is without prejudice for him to have a bond hearing before his division judge. As to the, the other counts, on one, there was $1,000 bond that was attached, and he was ROR'd on count 2 on the traffic capias. Okay. Malik Ham.
He's here, present, Judge Amain.
Mr. Ham is before the court on charge number 1 is carjacking with a firearm or weapon. 2 is grand theft auto. 3 through 16 are a violation of felony pretrial. Those are all no bond holds. The court finds probable cause. I'll hear from the parties.
Your Honor, so Mr. Ham, on count 1, I am going to be seeking a no bond hold and a finding of proof evident or presumption great. I understand that Judge Casey set a $250,000 bond. I would note that the affidavit contains information from the victim. The allegations satisfy the elements. The victim identified Mr. Ham, and I would note, a day after this, the carjacking, Mr. Ham was detained, arrested in the victim's stolen vehicle that he was driving.
Judge, I don't know if there's any information that is new to this court that was not available previously when bond was set in the amount of $250,000 on count 1. If there is no new information present before this court, we would object to the court changing the bond on count 1 or count 2.
Your Honor, I don't know that Mr. Reedy's argument has any legal basis. As the court knows and Mr. Reedy knows, there are judges that sign arrest warrants on second-degree and third-degree felonies that put no bond holds. And I've never heard Mr. Reedy, I imagine Mr. Reedy wouldn't have an objection if Your Honor said, well, there's no new information and the judge said no bond, so I'm keeping it at no bond. Judge Casey signed an arrest warrant where the standard is not, to sign an arrest warrant is not proof evident and presumption great. It's probable cause. I'm asking the court to make the determination that the higher burden has been set. And as the 4th ECA in the Florida statute states, if the court makes that determination, then Mr. Ham no longer has a constitutional right to bond. And it's up for the court to decide.
Well, of course, if an illegal bond is set, such as a no bond or on a second or third degree felony, then of course a court has an obligation to correct that illegality. There is no illegality in the $250,000 bond set by Judge Casey on count 1, and we would ask the court to keep that bond in place.
All right, so based on the affidavit at this time, the court does find probable cause. And as to count 1, I am going to make a further finding of proof evident presumption great. And I am going to hold Mr. Ham no bond until further order of the court for an author hearing.
And for the record, that is over our objection. However, that being said, in light of the fact that Mr. Ham has numerous no bond holds on the docket this morning, we will reserve any argument regarding proof evident presumption grade until such time as Mr. Ham can appear before his division judge, which I believe is Judge Porth.
All right. Okay, and the bond on 2 is $1,000. Okay, Justin Wolf.
Judge, Mr. Wolf is here, and he declined the services of public defender.
All right, Mr. Wolf is before the court this morning on a grand theft charge. Count 1, count 2 is commit theft, resisting recovery of property. Count 3 is grand theft, and count 4 is a misdemeanor case. So, Mr. Wolf, are you planning on hiring private counsel?
Yes, but I already have private counsel.
Okay, well, does the state wish to be heard? All right, so then your standard bonds are in place, sir, and you do have court before your, on the capias tomorrow before your misdemeanor judge, okay?
All right, thank you.
All right. Did we hear anything from Judge Lerner Renzovision in regard to Mr. Saunders?
No, I'll reach out again, Your Honor.
Come on up, Mr. Saunders. Wait, stay right there.
All right, we haven't gotten a response yet.
Oh, okay,
Sorry,
have a seat,
I was
sir.
just checking.
No problem.
DeMarcus Sampson,
Mr. Sampson is here present, and he declined the services of public defender, Judge.
all right, Mr. Sampson, do you have private counsel?
Right here. No, ma'am.
All right, okay. So Mr. Sampson is before the court on a charge of robbery with a firearm. And the court finds probable cause.
And, Your Honor, the state would be seeking a no bond hold upon a finding of proof evident or presumption great. Relying upon the arrest warrant, the probable cause affidavit, the allegations would satisfy the elements. The incident was captured on video surveillance at the bank. Mr. Sampson was seen in possession of the firearm, and he was actually identified by still photographs taken from the video by his mother.
All right, so the court finds probable cause and make a further finding of proof evident presumption great without prejudice. And at this time, Mr. Sampson, you'll be held no bond until you appear before your division judge, okay?
Okay.
All right, good luck, sir. Michael Consiglio.
Mr. Contiglio, come on up, please. He's approaching, Judge.
Mr. Consiglio is before the court on charge number 1 is driving while license suspended, and number 2 is careless driving, which is not for magistrate. The court finds probable cause.
Judge, in speaking to Mr. Consiglio, unfortunately, when I told him with the standard bond, he's not going to be able to afford that. He's been living here his whole entire life. He's 40 years old, Judge. He's right now looking for employment. He lives with his mother. They rent an apartment, and from what he advised me, his mother's retired and on Social Security, so she's finding where to post a bond. So we're asking the court to consider releasing him on pretrial release.
All right, state.
Yeah, I know. What was it for? Your Honor, I'm showing in 2012, Mr. Consiglio was sentenced to 3 years in state prison for felony DWS. He's also gone to state prison in the past on violent offenses: strong arm robbery, aggravated assault, robbery with a firearm or deadly weapon, carjacking, false imprisonment.
All right, and Mr. Consiglio's bond is $750. Michael Sussman.
Oh, Judge, Mr. Sussman, I apologize. He's a medical reset.
Okay, thank you. Evan Blair.
Mr. Blair is approaching. Come on up, sir.
All right, Mr. Blair is before the court, robbery by sudden snatching without a firearm. Okay, the court finds probable cause. I'll hear from the parties as to bond.
Your Honor, I see no history. I'd be requesting a $2,000 bond, no return to Rumors Bar, and no victim contact.
Judge, that's reasonable.
$2,000 is reasonable? All right, so his bond is $2,000. No return to, what's the name of the bar?
Rumors.
Okay. Diego Lopez Andrade.
Judge, he's approaching, and I've been advised he declined the services of public defense.
All right. All right, Mr. Andrade, you're before the court this morning. Count 1 is possession of drug paraphernalia. Count 2, resisting without violence. And count 3 is tampering with or fabricating physical evidence. Mr. Andrade, do you have private counsel?
No.
All right, so the court finds probable cause. Your bond on count 3 is $1,000, okay? Keith Brown. He was a medical reset yesterday.
Oh, Judge, medical reset.
Okay. And then Dustin Richardson.
He's here present, Judge, at Maine.
And Mr. Richardson is before the court. Charge number 1 is selling cocaine. Number 2 is distributing or delivering cocaine. All right, the court finds probable cause. Does the parties wish to be heard?
Oh, you, Judge. And speaking of Mr. Richardson, from what he advised me when he was arrested or picked up on these warrants, this is a complete shock to him. He's advising us that he's looking forward to his day in court because this is a mistaken identity. Judge, my understanding is that he has prior contact with the criminal justice system, but from what he advised me, he's never been convicted on any simple possession cases or even dealing. He has nothing like this on his record. He advised me, Judge, that he was working in landscaping, but unfortunately he suffered an injury, and right now that's preventing him from working. He lives in Deerfield Beach with his mother, been residing at the same location for 3 years, and she's a caretaker. Judge, we're asking for the court to consider releasing on Mr. Richardson on pretrial release. One other important matter for Mr. Richardson is basically he has a daughter that he hasn't seen in about 13 years. The child's mother was, from what he advised me, preventing him from seeing his daughter. Mr. Richardson, he's been working, saving up. He paid up all his back child support, and the mother of his daughter is now letting him see his daughter this Sunday for Father's Day. That's very important to Mr. Richardson. He's asking the court if the court would consider releasing him on pretrial release.
No, Your Honor, first off, and part of the issues might be, it would appear since 2009 he hasn't been paying child support because that's when his license was first suspended for not paying child support. So I want to get that out of the way. I would also note, and I imagine Mr. Romero isn't aware of this, these alleged deals were video recorded. So I know Mr. Richardson's claiming it was not him. we'll see who's on the videotape, but there's a moment. Two separate detectives, Broward County Sheriff's Office detectives, swearing in affidavits that he conducted drug deals with undercovers. He has been to state prison in the past. 2008, felony battery due to priors, battery on a law enforcement officer, resisting with violence, and unlawful threats of harm against law enforcement, 2 years state prison. He's also been convicted in the past for violating an injunction against domestic violence. One moment, Your Honor.
And Judge Wild looks for other priors. Like I said, I know he has prior contact, but from what he's telling me, and I don't think Mr. Lender said anything to the contrary, he has nothing similar to these offenses. And obviously, when he goes through discovery, they're going to request a video through discovery, and they're going to see what's going on with that. And I didn't hide it. Yes, there was back child support. That's what he went ahead and paid to actually rectify the situation. So now he's going to his daughter. He's not claiming that he was not delinquent on child support. He was. And I believe maybe that was maybe a reason why he didn't get to see his daughter. But now he is current judge, so he's asking for the court to consider releasing him pretrial.
And Your Honor, and I don't mean to go back and forth. My point is, and I believe what was said was, and it was implied, that the mother was keeping the child away from Mr. Richardson. I just wanted to point out, it appears there was a reason for doing so. He wasn't fulfilling his obligations. Your Honor, he has a criminal mischief, 2017, resisting without violence and trespass, another criminal mischief in 2015.
And these incidents occurred, Judge, back in August and October of 2018. It does not appear as though Mr. Richardson has been in any contact with the criminal justice system since then.
He hasn't been arrested for any.
All right, so at this time, I am going to where does Mr. Richardson live?
Look, I live with my mother.
And what's that address?
It's 5360 Northeast 5th Terrace, apartment 6107, Pompano Beach, Florida, Deerfield Garden Apartments.
And where do you work?
I work for a gentleman, an older gentleman, doing his lawn work and landscaping and stuff, part-time.
How long have you been doing that?
I've only just started working for him for a couple weeks ago. It's on and off because it's summertime and my daughter likes to spend summertime with me because my mother works.
Oh, how does your daughter
I
spend
have
time
two
with you?
daughters. I have an 11-year-old and the 15-year-old that I haven't seen that I just paid $45,000 back child support.
Okay. What does your mother do?
My mother's a nurse at Broward Health Center, Broward's Children's Health.
All right, I'll release Mr. Richardson to level 2 pretrial supervision.
Thank you, Your Honor.
And that's also going to include random drug testing.
Yes, ma'am.
All right, I guess we have no answer on Mr. Saunders so I'll just sign the order to transfer him to Judge Lerner Wren, and he'll see her as soon as possible, okay?
I did send the text letting her know that we transferred.
All right.
We didn't transfer, but that he was taken into custody.
You're right, so I'll leave the bond at $25 and he'll go see Judge Lerner Wren, okay? All right.